We're here for a one-on-one interview with Professor Konyinsola Ajayi, a senior advocate of Nigeria. Thanks for joining us, Professor Konyinsola Ajayi.
Thank you for having me.
Now, the APC National Chairman, Adams Oshiomhole, on Friday said that he has called on senators to impeach Senate President Bukola Saraki, Dr. Bukola Saraki. He said he has no moral and legitimate grounds to occupy that position. As a minority member, now that he has decamped to the PDP, we've often heard two-third majority to impeach. You need a two-third majority. What is the true position of the law on the two-third majority needed for impeachment proceedings? Is it two-third of members present, or is it two-third of the 109 senators?
Right. I think before I say something about that, I should mention that the statement by the chairman of APC obviously is a political statement and is part of the game that we are seeing unfold towards the holding of election next year, and sort of the parties testing themselves as to who will come out on top. But more directly to the question, it's a simple, straightforward, I believe, constitutional issue that has agitated the minds of our courts at the three levels. In other words, the trial courts, the appeal court, and the Supreme Court. And what they had to interpret were about three sections of the Constitution, basically. So the first provision to look at will be section 52C of the Constitution, which provides that the Senate President or the Speaker, as the case may be removed from office, not impeached, because that is a technical legal term in itself, which has quite a negative connotation. But a Senate President can be removed as a Speaker under section 52C of the Constitution if two-thirds of the members of the relevant House vote for such resolution. Question then
Total
is,
number?
Two-thirds, well, what the Constitution says, I'm just telling you what the Constitution says. Two-thirds of the members. Then we jump to section 54 of the same Constitution, which provides for a quorum of the Senate or the House, which would be the starting block. And what that section says is that the quorum shall be 1/3 of all the members of the Senate or the House, as the case may be. So that clearly, in the case of the Senate, would mean to begin this discussion at all, there must be 1/3. You know, this is 30 plus 34, 35, 36 members present. Then you have a quorum. Then the last section that comes to play, section 56, which provides that except as otherwise provided in the Constitution, the resolutions of the Senate or the House, as the case may be, will be by a vote of two-thirds of the members present and voting. So, question is, the removal will be by resolution. Would it be just those plain words that would get the Senate President removed, or something else? Mark you, the Constitution is subject to other provisions of the Constitution. And so where you go to will be section 52C, which says something totally different. It says two-thirds of members. And so clearly, without even the aids of the courts, it is two-thirds of 109. But the Supreme Court, in the case in two cases, has looked at this. The case of the former governor of Plateau State, Darie, the court had to look at what is needed to remove some from the House and from the
government.
And also in the case of Ladoja in Oyo State, looking at similar provisions, Supreme Court also looked at these things.
The precedent. Yeah.
And it's clear as they have interpreted the constitutions, that you need 109 senators sitting and present, and then you get 2/3 of that number. Except, for instance, as we know, a member, has been lost to death, or maybe resignation. But we know there are, 1 or 2 members of the Senate that passed on. Hence, we have elections in Katsina State, very
This
soon.
weekend.
Yeah.
Yes.
So clearly, for APC to have its wish, it will have to ensure that every senator
It's present.
is present.
That's very clear then. Now, we've seen wanton disregard for court orders by the federal government, even though we have a professor of law as the vice president. The Minister of Information and Culture says the government flouts court orders in the interest of national security. The chief law officer of Nigeria, Justice Mr. Abubakar Malami, also echoes this position. Are these reasons legitimate to disobey court orders?
When you begin to disobey court orders, then you are inviting the public not to respect government itself, and you are inviting us to anarchy. The Minister of Information is a politician, a good publicist, speaks a lot, and I guess he was just speaking to his constituency.
And you can forgive him.
And, well, I'm not sure, because he's a learned gentleman and of this experience, knowing that words matter and that, religion also, as politics, could be opium of the people. And so we could take that as an indication that what we consider to be national security is more important than law and order. But at the base of national security itself is law and order. So, for instance, the State Security Service is set up by law and has its powers under the law and is able to do what it does because the laws say so. Now, if we leave it to the executive to determine whether to obey an order of court or not, then why go to court at all? Why do they charge people to court if they would choose what they think is right or wrong? So it cannot, by any stretch of your imagination, be right for any government anywhere to disobey a court order.
Now, earlier this week, the Economic and Financial Crimes Commission froze and then unfroze accounts, state accounts of Benue State and Akwa Ibom State. These accounts are important for payment of salaries and the day-to-day running of activities of the state. Does the EFCC statute give such powers to the Economic and Financial Crimes Commission to freeze accounts of states?
I think clearly not. EFCC is a creature of statute, and everything it does is subject to that statute. That statute itself is subject to our Constitution. So the starting point is not even EFCC Act, it's the statute. And our statute creates a federal government where state governments are themselves sovereign. Our Constitution creates consolidated accounts for the states as it does for the federal government. So you have a federation account, consolidated revenue fund for the federal government, you have a consolidated revenue fund for the state government. And the money that goes into those accounts are income of government, treasury receipts, taxes, imposts, and levies. That's what goes there. It's not stolen money. Government doesn't steal money. EFCC can freeze proceeds of economic crime and no more. If there's money in a bank account that belongs to government, it cannot be stolen money. So by no...
Does it belong to an individual?
It doesn't belong to an individual. So I do not know where Magu got that advice from, that he could do that. It is an absolute travesty that he could think he has the powers to ride roughshod over a state government. Because, mind you, that governor is a sovereign. That governor is not subject to the judicial process. And the framers of our Constitution did that for a purpose. So, as a matter of fact, it was just by by chance that the Supreme Court even allowed the EFCC to come into the affairs of state governments at all. Because in the case of Ondo State and Attorney General of the Federation, which is, went to the Supreme Court in time of Obasanjo, was whether the Supreme Court, the EFCC and the federal government could at all concern itself with such activities in a state. Well, the Supreme Court said, because the Constitution provides in Section 16 that we should abolish corruption in all ways in which we could, would lean towards allowing EFCC and the federal government to, to prosecute this at the state level, which is fine, to a level. But then that is what it says. So if a state official steals money, yes, go after it. If the governor steals money, there are things to be done. Report him to the House of Assembly, get him impeached, and then try him. Or wait for him to leave the office and then try him. But to freeze account of a state is to castrate the state. It is to remove fiscal responsibility. So how will salaries be paid? How will hospitals be run? How will state security itself be assured? So, I think it's terribly bad and very sad. Well, luckily, he has reversed himself, and I hope no one would ever dare do this again.
Now, in recent times, we've seen a culture of impunity by the executive arm of government. Case in point, the DSS raid on the residence of judges, Tuesday's siege of the National Assembly, and policemen in Benue State preventing some lawmakers from gaining entry into the Assembly complex. What's the implication of this, and how do we ensure that all arms of government adhere strictly to the principles of separation of powers?
Well, tough. I hope the acting president continues to display the immense courage that he displayed on Tuesday. I hope he continues to show the leadership and wisdom that came to the fore on Tuesday. And what do I mean? I hope he would cause the IGP to continue to do what it is doing, which is to investigate how this came about. Because this actually could be treasonable felony, which is a serious offense that carries life sentence. It certainly is an offense under the laws governing affairs of the National Assembly, which provides that contempt of the Assembly or obstructing legislator are offenses that carry sentences of 6 months or 2 years, as the case may be. It also entails the crime of encouraging mutiny, because those officers that went to the National Assembly were acting contrary to their duty to protect the Constitution of Nigeria.
They took wrong orders.
They took wrong orders. They acted contrary to their oath of allegiance, which is mutiny. So those who did that and the people who asked them to do so should be tried. And except they are tried, except this is seen as contravention of Section 1, Subsection 2 of our Constitution, we would not stop it. Coups are stopped because people are tried. If they're not tried, some rogue will try this again.
So you believe it doesn't end at the sacking of the SYDG, Mr. Lawal Dara? There should be a trial, and those responsible should be brought to book.
I hope this is done. Section 1, Subsection 2 provides that no one should try and take over a government or any part of it. So what is part of government? The National Assembly is one arm and part of government. Judiciary is one arm and one part of government. The executive is. Now, when we go through history of coups in this country and other places, what do they sack? Only the legislature. Because there would always be an executive, there will always be a judiciary. So that weak link, that body that is sacked always is the legislature. So I can imagine what would happen if we begin to think that we can seize the National Assembly, stop legislatures from working, usurp powers, basically. And, we've seen this happen in River State, in the last civilian regime, where the courts were locked up by a governor for such a long time. It's absolute impunity.
But we seem to have a culture that doesn't punish bad behavior. People just move on to the next news and distraction. Are there implications for this?
Well, the implications for not dealing with bad behavior is replication of bad behavior. The acting president is known to be a very disciplined and principled man. And I think if the evidence is clear, the right thing will be done. Now, it's not his responsibility, mind you, to prosecute. It's not his responsibility to investigate. Now, what he can do, he has done. Sack and ask the matter to be handed to the police to be investigated. So let us see what happens. Let us see whether it will be properly investigated. And if the evidence points to prosecution, let's see what happens.
It's defection season. We've seen a flurry of activities, the cross-carpeting, a gale of defection in the country in recent times. The relevant sections of the Constitution states that there must be some type of polarization, disunity within the party. But we've seen a lot of politicians flout this and defect for personal reasons, very personal reasons. What actually is the position of law on this subject matter, and is it enforceable? Could you take a politician to court for defecting unconstitutionally?
Well, people have. So starting with Fedeco and Goni, or Goni and Fedeco. Goni used to be the governor of Borno State. And, it came up in the Supreme Court. And it would interest you to know what the Supreme Court said. It said clearly the act of carpet crossing of politicians for personal gain and personal reason is against the spirit of the Constitution and is absolutely deplorable and bad. It is against the political moral fiber of the nation. So they were clear. They say, however, when a party has a division and is split, and you are in a faction that is so small as not to allow you a platform to express your political preferences, you're allowed to join another party. Because the Supreme Court was concerned about the man that is in a party that belongs to a part of it that will not allow him to express himself. So what we're looking at is what is the vision. And in a number of cases, the court have looked at it. There's a Court of Appeal decision, Delta State House of Assembly against Democratic People's Party, where the Court of Appeal, following Goni's case, also said more or less the same thing. And they said that it must more or less be where you have two executives, two excos.
Like the PDP a while ago before.
Yes. Yeah. So when you have that, it's clear. But it also says, they also say when you have two parties bearing the same name, but not just that, but where it's clear that there is a division. So this takes us to what is happening now. Now we know clearly that PDP today is not divided. So Mr. Senator Akpabio, who says everything is turning around, has crossed carpet. Now, I think in his case, he'll be caught by the decision of the Supreme Court in Abegunde, who and the House said he had to lose his seat. Supreme Court said he had to give up his seat because there was no division. Yes. And there's no division at the state level. So there's no division in PDP today, and he's crossed carpet. So he should
watch it.
Well, not watch it. Saraki shouldn't allow him into chambers. On the other hand, before this gale of defection, a party was formed called RAPC. The same way as we had New PDP. And more or less, this, the same set of people that formed New PDP and moved to APC are these same set of people that have more or less formed our APC and moved to PDP. It is clear to me that there is a division in APC because some people have gone to court to challenge the convention, to say that the election was illegally held. Quite a number of them were not allowed to take part in the process. And they also have their own chairman.
And these are legitimate grounds.
Well, I don't know. I'm not in the party,
yes.
but this is what they say. What we know is that you have a large number of people, so large that the balance of power was changed in the National Assembly. And so you cannot say in that instance that there has been no division or there is no cleavage in APC. Clearly there is. And that's why you would see that a number of APC chieftains are sort of vehement and speaking as to the effects of this, much as on the one hand they say that they're all empty shells that will not affect their fortunes. But it's clear to all that can see that there is something really wrong with APC, and they can't run away from the fact that there is a division in the party.
Professor Konyinsola Ajayi, it's been an absolute pleasure talking
Thank you.
to you. Thanks for joining us.